Hi everyone. Today we are going to discuss about the introduction to intellectual property rights, types of intellectual property. I'm dealing with patent, trademark and copyright. Over the past 2 decades, intellectual property rights have grown to a stature from where it plays a major role in the development of global economy. The domain of intellectual property is vast. Copyrights, patents, trademarks, and designs are known to have received recognition for a long time. Newer forms of protection are also emerging, particularly stimulated by the exciting developments in scientific and technological activities. What is an intellectual property? Intellectual property refers to the creation of the human mind, like inventions, literary and artistic works, and symbols, names and images, designs used in commerce. Intellectual property can be divided into two: industrial property and copyrights. Industrial property include inventions, that is protected by patents, and trademarks, industrial designs, and geographic indications of the source. Copyright mainly deals with artistic or literary works such as novels, poems, plays, films, paintings, etc. The most noticeable difference between intellectual property and other forms of property is that intellectual property is intangible, that is, it cannot be defined or identified by its own physical parameters. It must be expressed in some dictatable way to be protected. Generally, it includes four separate and distinct types of intangible properties, namely patent, trademark, copyright, and trade secrets, which are collectively referred to as intellectual property. But the scope and definition of intellectual property is constantly evolving, so newer forms are included day by day into intellectual property. In recent times, geographical indications, protection of plant varieties, protection of semiconductors are also brought under intellectual property. Here we will discuss in detail about patent, trademark and copyright because it is specified in the syllabus, and we will briefly describe about trade secret, geographic indications and plant breeders' rights. Next, about intellectual property rights. Intellectual property rights are the rights given to a person over the creation of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. Intellectual property rights provide certain exclusive rights to the inventors or creators of that property in order to enable them to reap commercial benefits from their creation efforts or reputation for a particular period of time. The protection of intellectual property rights may take several forms depending mainly on the type of intellectual property and the type of protection sought. Let us go through the milestones in the history of intellectual property system. A Venetian law of 1474 made the first systematic attempt to protect the invention by a form of patent which granted an exclusive right to an individual for the first time. So we can say that it was in Italy where the protection of an intellectual property initiated. Then, towards the end of 19th century, new inventive ways of manufacture helped to trigger large-scale industrialization, accompanied by rapid growth of cities, expansion of railway networks, and the investment of capital and a growing transoceanic trade. New ideas of industrialism, the emergence of stronger and centralized governments, and nationalism led many countries to establish their modern intellectual property law. At this point of time, the international intellectual property system also started to take shape with the setting up of the Paris Convention for the Protection of Industrial Property in 1883 and the Verne Convention for the Protection of Literary and Artistic Work in 1886. And by the year 1967, the convention establishing the World Intellectual Property Organization listed out the subject matter that should be protected by the intellectual property rights. It includes the literary, artistic and scientific works, performances of the performing artists, inventions in all fields of human endeavor, scientific discoveries, industrial design, trademarks, etc. And after this convention, the World Trade Organization was established. With the establishment of WTO or World Trade Organization, the importance and role of intellectual property protection has been crystallized in the Trade-Related Intellectual Property Systems Agreement, that is known as the TRIPS Agreement. It was negotiated at the end of the Uruguay round of the General Agreement on Tariff and Trade Treaty in 1994 or the GATT Treaty in 1994. So, these are some milestones in the evolution of an intellectual property system. So, as I already mentioned, that the TRIPS Agreement is very much essential while we are considering about the intellectual property system. So, let's go through the key features of TRIPS. The TRIPS agreement encompasses in all principle all forms of intellectual property and aims at harmonizing and strengthening standards of protection and providing for effective enforcement of both national and international level. So, in this particular agreement, there is a detailed description about the intellectual properties and how they can be harmoniously maintained. So, this agreement is very crucial. It also addresses the applicability of general GATT principles as well as the provision in International Agreement on Intellectual Property. It establishes standard for availability, scope, use, enforcement, acquisition and maintenance of the intellectual property rights. Furthermore, it addresses related dispute prevention and settlement mechanism. Formal provisions are addressed in the Part 6 and 7 of the agreement, which covers the transitional and the institutional arrangements respectively. So, in this particular agreement, there is a detailed description about the intellectual property system. The TRIPS agreement, which came into effect on 1st January 1995, is today the most comprehensive multilateral agreement on intellectual property. The areas of intellectual property that it covers are copyright and related rights, trademark including service market, geographical indications including appellations of origin, industrial designs, patents including protection of new varieties of plants, the layout designs of integrated circuits, the undisclosed information including trade secrets and test data. So all the necessary details about the intellectual property is covered in this TRIPS agreement. Both the industrial property as well as the copyright is also detailedly mentioned and how they are maintained and how the dispute should be negotiated. Everything is detailedly described in the TRIPS agreement. So that is just a brief description about the key features of TRIPS agreement. Now we have an understanding about intellectual property, how an intellectual property system evolved, and what all are the key features of the TRIPS agreement. Now discuss about the intellectual property system in India. In India, the protection of an intellectual property is initiated by the introduction of an act, that is the Indian Patent Act, which was introduced in the year 1856, which remained in force for over 50 years, but later it was modified and amended, and it was called the Indian Patent and Design Act 1911. After the independence, another amendments were added and this law was modified and it was called the Patent Act 1970. Until recently, it has many amendments. The amendments that is added to this particular act, and about this act in detail, we will discuss it later. So, in India, specific statutes protect only a very few or a small number of intellectual properties. Till recently, only 4 forms were protected. And how is this intellectual properties protected? They are protected by granting either copyright, patent, design and trademark. So in India, there are separate rules under which all these intellectual properties are protected. The copyright were regulated under the Copyright Act 1957, patent under Patent Act 1970, trademark under the Trade and Merchandise Marks Act 1958, and designs under Design Act 1911. So this was initially how the intellectual property system works in India. So these intellectual properties, the copyright, patent, designs and trademarks were regulated under these laws. With the establishment of World Trade Organization and after India became a part or became a signatory to the agreement, India have passed several new legislation for the protection of intellectual property rights to meet the international obligation. So here I provided some of the changes or the legislation that are passed by India. The trademarks called the Trademark Act 1999 means the trademarks are protected under the Act, Trademark Act 1999. The Design Act 1911 was replaced by the Design Act 2000. So necessary modifications are made. And the Copyright Act 1957 amended a number of times, and the latest is called the Copyright Act, that is amended 2012. The latest amendments are made to the Patent Act 1970 is in 2005. Geographical indications of goods, the Registration and the Protection Act 1999, and Protection of Plant Varieties and Farmers Rights Act 2011. So initially on these geographical indications of plant varieties were not protected, but after India being a signatory of the WTO TRIPS agreement, it has to pass new legislations, it has to follow new rules in order to meet the international obligations. So that is how these all new laws were implemented and some of the old laws were amended. Till now, we have discussed about intellectual property and we have also discussed a brief history of the intellectual property system and the intellectual property systems in India. Now, we are going to discuss about the types of intellectual property. I already mentioned that intellectual property can't be defined in a very simple manner due to the development in technology or in the scientific field as well as in the literature field. New types of intellectual property is being added to this heading, that is intellectual property. So I am mainly focusing on patent, trademark and copyright as per the syllabus, and we will briefly discuss about some other types. So the protection of intellectual property may take several forms depending mainly on the type of the intellectual property and the types of the protection sought. So, first intellectual property is the patent. A patent is a right granted by a government to an inventor to exclude others imitating, manufacturing, using or selling the invention in question for commercial use during a specified period. It means that if an inventor has gained a patent for a particular invention, he can reap the commercial benefit for a particular period, or for a specific period only he can gain the access to that particular innovations. Okay, and a patent is granted for an invention including a product, innovation or improvement in an invention, the process or product of an invention, and for a concept. Okay, now let's detailedly look into patents. There are some requirements to gain a patent. They include novelty, inventiveness, industrial application and usefulness, patentability, and disclosure. Let us discuss in detail. The first one is novelty. What is novelty? Novelty means something new. That is, the invention must be new and should not be already known to the public. A novel invention is the one which has not been disclosed in the prior art, where prior art means everything that has been published, presented or otherwise disclosed to the public on the date of patent. It means that the invention, whatever it is, a product or a process, it should be entirely new. That is, the public should not have any idea about that. And how invention, or what all inventions are considered as novel. So the guidelines are specified in section 13 of the Indian Patent Act with provisions of section 29 to 34. So here I briefly mentioned about it. So an invention shall not be considered to be novel if it has been published before the date of filing of the application, or that is under processing in India. It means that if a person wants to gain patent over a particular product, for example a product, then he can only publish the details or about anything about that product only after gaining the patent. Okay, he can't publish the detail before filing the application, or he can't even publish it even if it is under processing, okay, under the procedures of patent. Okay, in India he can't publish it. Then an invention shall not be considered to be novel if it has been published before the date of filing of the application in any of the document in any country. It again specifies that he can't publish it not only in India but in any place, in any document in any country. Then invention shall not be considered to be novel. It has been claimed any of the claim of any other work which is filed before the application but published after the said application. It means that our work should be entirely new. We can't claim someone else's work that is already filed. Okay, it doesn't matter whether it published before us or published after us, but if the application of a particular a particular work has been already filed in the patent office, and then after that we are applying for patent and we are claiming about some specifications of that particular work, then our work won't be novel. Then an invention shall not be considered to be novel if it is a knowledge or oral or otherwise available within any local or indigenous communities in India or elsewhere. So I already mentioned that it can be a concept, or it may be a process or an invention, but it should not be an indigenous secret or indigenous knowledge about anything in India or any part of the world. We can't claim an indigenous property or their knowledge as a novel product, that is we invented it, so it is illegal. So that is about novelty, that is the work should be new and should not be known to the public. and we must keep these points in mind. So without gaining a patent, we can't publish it, and also we can't get a patent on knowledge of the indigenous communities. Now, the second requirement is inventiveness. Inventiveness means the invention should not be obvious to a person skilled in art and should represent an innovation. It means we can't claim another use of an already known process to be a novel invention or as an innovation. So, as I already told, it should be novel as well as it should be inventive. It should be an innovation, an extraordinary something, or that is completely new and it is unique. Next, the third requirement is the industrial application and usefulness. So, an invention is capable of industrial application if it satisfies the following three conditions cumulatively altogether. That is, it can be made, means it should be able to synthesize, and it can be used in at least one field of activity, and it can be reproduced with the same characteristics as many times as necessary. So industrial application means large scale production, so it can be reproduced with same characteristics as many times as necessary. And an invention to be patentable must be useful. Okay, if the subject matter is devoid of utility, it does not satisfy the requirement of the invention. An invention should be useful to the community, to the society. So the usefulness may be commercial or non-commercial. It doesn't matter whether it is commercially useful or non-commercially, but at least it should have a use. So that is the third requirement, that is the industrial application and usefulness. Next, the fourth requirement is patentability. Patentability means not all the subjects or the innovations or the products are patentable. There are some products that are not patentable according to the law of specified country. The subject matter of a patent must be patentable under the existing law and its current interpretation. Means the criterion varies from country to country and the time within the same country. So within time the criterion may be changed, and from country to country it means in some countries some products are patentable, but in some countries it are not. So let's go through some of the non-patentable inventions within the meaning of Section 3 of the Patent Act 1970. So first one says that an invention which is frivolous or which claims anything obviously contrary to the well-established natural law, it is not patentable. That is something, either a product or an innovation or a technology that is completely contrary to the existing natural law, it can't be patented. Then an invention which exploit the public order or morality or cause harm to human, animal or plant life and health or to the environment can't be patented. And third, the discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature can't be patented. It is obvious because patent actually provides or gives an absolute right to a particular person for a particular period of time for gaining the commercial benefit from that product. So we can't give patent for a particular theory or about a living thing or a non-living thing that is naturally occurring. Okay, for example, if someone discovers a new species of organism or a plant, so it actually occurs naturally. So it belongs to everyone, but no one has a right to exploit it. So it can't be patented. And the discovery of new forms or process of a known substance that does not increase the efficacy. like isomers or complexes. So if already a product is known and another form or variant of that particular product is discovered, it can't be patented until it increases its efficacy. It means that if there is a process that is already known and a new version is identified, but it is far more better than the already known one and it has a high efficiency, then it can be patented. But already known process without any increase in efficacy can't be patented. The Section 3 of the Patent Act 1970 also detailedly explains about so many other non-patentable matters like a method of agriculture or horticulture, any process of the medical, surgical or therapeutics, then literary or dramatic or music work, and a mere scheme or rule or method of performing a mental act. So there is a detailed description. So if anyone want to know in detail more than this, they have to refer the Patent Act 1970. So I think these four key points will give an idea about the non-patentable matters. So these are the things that deals in the Section 3 of the Patent Act 1970. The Section 4 of the Patent Act, and it also falls under the subsection 1 of the Section 20 of the Atomic Energy Act 1962, is also very much important in considering the patentability. It says that no patent shall be granted for invention which in the opinion of the central government are useful for or related to the production, control, use or disposal of atomic energy or the prospecting, mining, extraction, production, physical and chemical treatment, fabrication, enrichment, canning or use of any prescribed substance or radioactive substance or the ensuring of the safety in atomic energy operations. It means that nothing related to the atomic energy or the radioactive substances are patentable because there is a chance of exploitation. So no one has the right to gain patent in such matters. Okay, that is about the Section 4 of the Patent Act. Now, the final requirement for the patent, that is the disclosure. Disclosure means the inventor is required to describe his invention in sufficient detail so that the person of normal skill is able to reproduce it. So, the inventor must be able to convey his ideas with others in simple terms. Okay, and if the invention is in case of a biological entities that is already known, the animal may be simply named. So it will be easy to understand. So there is no need to use the scientific terms. The animal is already known, then we can simply name by using it the common name. Then in case of organisms that are genetically modified, the nature and method of modification has to be fully marked. In addition, a sample of microorganism, cell lineage, etc. are being patented may be required to be deposited in the designated culture collection. And why this is necessary? Because it can be used as a reference in case of dispute concerning its novelty or unauthorized use, and it can also be used as a source for the microorganism or cell lineage for the authorized user. Okay, so these are the requirements for a patent. So a patent may be viewed as a contract between the society and the inventor, wherein the inventor discloses his invention to the society. So in return, what he gains? Protection for his work. Okay, the protection for his work from the society, and he also gains the control over the commercial aspect of his invention. So, the disclosure of an invention gives an opportunity to other inventors to improve upon the various features of the invention so that it became more efficient or useful, and in return it also developed the scientific and economic progress of the society or the nation. So that is all about the requirements for a patent. Now, about the duration of a patent. It is detailedly expressed in the section 53 of the Patent Act 2002, that is amended on 2002. It says that the duration will be from 50 to 20 years from the date of filing the application for the patent. 50 to 20 years from the date of filing of the application. But there are some limitations for the patent. There are two basic limitations. They include limitation of time, only 15 to 20 years that he can solely claim that is belongs to him. Then limitation of space. It means a patent is valid only in the country of its award and not in any other countries. But now there is another modification that has taken place where we can also claim this patency in some other countries, but we have to go for further procedure that we will discuss in later. So these are the two limitations of the patent. Next, about the procedure of a patent, how one can gain a patent. An inventor files a properly prepared application according to the prescribed performa with the patent office of the concerned country. So we have to fill the application according to the standard rules, and then we have to file it in the patent office of the concerned country. If it is in India, the Indian Patent Office has its headquarters at Kolkata and branch offices at Chennai, New Delhi and Mumbai. And the applicant has to file the application according to the territorial limits where the applicant, or if there are more than one applicant, where the first applicant normally resides. So if a person belongs to Chennai want to file an application, he has to file it in Chennai, or if the person belongs to Mumbai, he has to file it in Mumbai Patent Office. Okay, and after the submission, the applications are screened to verify if they are complete and in order for publication. So after screening, we publish the application. So if the application is incomplete, time is allowed for their correction, and ordinarily an application will be normally done in 18 months after the application was filed. So if we want to publish it before 18 months, there is a specified fee for that. So after the fees are paid, it will be published before 18 months. So if after publishing, if anyone wishes to challenge the award of the patent, and someone finds that this particular invention is not capable of patency, then one can challenge the patent within a specified period of time. For example, in India, it should be within 4 months from the date of publication. Okay, so within 4 months after the publication of the particular application, one can challenge it that this product can't be patented. So if someone has challenged a particular application, it is examined for their sustainability for the award of patent, and report along with the objections is communicated to the applicant. So we inform the applicant that these much objections are came against your application. So the inventor may withdraw the application, modify and resubmit it, or submit it with an explanation for the objections raised by the patent office. So in India, normally all the objections must be addressed to within 15 months of the first examination of the application. So after the publication of the application, within 4 months, anyone wish to challenge the application should inform the patent office. Then the patent office will screen and examine the particular objections and it will convey it to the applicant, and after that the applicant may withdraw, modify and resubmit, or submit it with an explanation for the objections, but it should be done within 15 months. So in case the patent application is not challenged, the patent is awarded within a specific period of time. In India, it will be done within 6 months. Okay, and it also provides that the objections has been removed and the application is said to be sealed. It means the patent is awarded and it is complete. So if the application is not challenged within 6 months, the entire procedure will be concluded. But if a patent is challenged, the arguments and counter arguments of both the applicant and the person challenging the application are heard by a competent authority of the patent office, and final decision is taken on award of patent. Okay, that is the procedure. And if a patent application is rejected due to a contest following its publication, the main features of the invention are stand disclosed. The inventor cannot now resort to the option of trade secret. Therefore, it is the interest of an inventor to ensure before filing a patent application that the application is not likely to be rejected, at least on account of a contest by a third party. Okay, so if someone want to apply for a patent, he must take utmost care in filling that application and in presenting his work, because once rejected it can't be further followed. Okay, and a patent has to be renewed every year by paying a certified amount, and report on the working of the patent has to be submitted annually. So it is not like that once you gain the patent and after that you can stop the work. No, we have to submit an annual report based on the current working or the current situation of the particular product. In a case, patent remains unused for 3 years from the date of award, an interested party may file a petition for grant of a compulsory license. It means if once a person have gained a patent but it remained unworking for a particular 3 years, then another third party can apply for a compulsory license, and the patent office will grant that license, and then that person will gain the right over that particular invention. So we must continue to work in that particular work. So that is a brief description about the procedure of the patent or to gain a patent. So we must take utmost care while we are filing the application, and if there are any challenges regarding it, we must give essential proofs and explanations against that objections. Okay. Next, about the types of patent application. This is a brief description about the types of patent application. Mainly there are 4 types of patent application. First one is ordinary application, that is an application has been filed directly in the Indian Patent Office. Second one is convention application. Third one is the PCT application, and fourth one is the divisional application. Okay. And another type is a patent of addition. Is actually filing after filing an application for a further modification. So after filing a particular application for a patent, we have modified an innovation or there are some improvements, we can file these modification and improvements along with that application, and that is known as the patent of addition. So let's look in detail what all these application means. First one is the ordinary application. So as I already mentioned, it is application which has been filed directly in the Indian Patent Office. An ordinary patent application refers to an application filed without claiming any priority rate and is made without any reference to any other application under process. So we are not claiming priority, or we are not referring to any other work that is under process of the Indian Patent Office. We are just filing application for the patency regarding solely on our work, then that type of application is known as the ordinary applications. Therefore, in an ordinary patent application, the priority date and the date of filing coincides. Priority dates means if there are two works, then the one which is claimed to be the first one, that is we call the priority date, but in case of ordinary application, the priority date and the date of filing coincide. And an ordinary application must be accompanied by a complete specifications and claims. Okay, we are not referring to any other work, so we must give all the details about our work in this particular application. That type of application is known as the ordinary application. Next, about the convention application. So this is just opposite to that of the ordinary application. This application is filed to gain priority. It means the applicant claims priority based on a fairly similar application filed in one or more of the convention countries. It means similar works has filed an application to gain patent in different countries or within the same country. So in order to gain a priority, means this is solely my work and I am the one who initiated this work, that type of application that is applied to gain priority is known as the convention application. And each country enables a specific time within which the convention application may be filed claiming priority. It means that already we have filed an application for patency and then we are again filing a particular application for the priority. So each country has a specific time for this convention application. For instance, in India, the Indian Patent Office enable a period of 12 months after the date of filing in one or more the convention countries within which the convention application may be filed. It means that if one has applied for patency, so if we want to gain a priority over that work, then within 12 months after the date of filing that application, we must file the convention application. So that is all about the convention application. Next is about the PCT application. A PCT application is governed by Patent Corporation Treaty, is an international application that helps to patent one's invention up to 142 countries. Initially, I mentioned about the limitations of a patent. Then basically it has two limitations, limitation of time and space. There I already mentioned that there are some further procedures through which we can gain a recognition or patency in up to 142 countries. So this is the procedure through which we can gain recognition in up to 142 countries, that by filing a PCT application. So this type of application is for a person seeking widespread recognition and protection of his invention. The PCT application is the best choice. So how this PCT application is filed and the procedures, that is not that much necessary, but I will briefly explain it. So one can file this PCT application in the Indian Patent Office, which is acting as a receiving office. So we can directly file it in the Indian Patent Office, or we can file directly it in the International Bureau of World Intellectual Property Organization, that is the WIPO, that is concerned with this particular type of application. But in order to file our application in WIPO, we must need a foreign filing permit from the Indian Patent Office. So only after obtaining the foreign filing permit from the Indian Patent Office, we can file our application, that is the PCT application in the International Bureau of World Intellectual Property Organization. Then applicant can file in the International Bureau of WIPO after 6 weeks and within 12 months of filing an application in India. It says that after filing the application in India, after 6 weeks or within 12 months, we can apply in the WIPO. So there are several advantages of pursuing international protection through a PCT application. Means that by filing a single international application, one will be able to protect his invention in up to 142 countries. So we are getting a wide recognition. Okay, and from the date of filing of the international application, there's a hefty time period of 30 to 31 months is provided to the applicant in order to file a national phase application in his selected countries and the test of feasibility of his invention. So within that 30 to 31 minutes, 30 to 31 months, one can apply in the selected countries from which we need that patent, and we can see whether our invention will get a patent from these countries or not. And the WIPO will inform us regarding the status of our application. And it also gives the applicant a reasonable idea of the patentability of the invention before incurring charges for filing and prosecuting the application in each country. Okay, so we get a wide recognition, so that how we gain patent from different countries through a single application, that is the PCT application. Divisional application is the final type of application. Here, in a single patent application, the applicant has considered more than one invention. So if a particular person has more than one invention and he wants to gain a patency in all of them, then he can file this divisional application. Okay, he may file for separate patent application, but he can also apply this divisional application. So okay, so in one application we are applying for more than one invention. Such applications are known as the divisional applications. Since all divisional applications arise out the same patent, okay, it means in a single application we are gaining patency, so all of them has a same priority date. Okay, and the applicant could file for a divisional application with regard to any matter contained in the original application. So initially we have to file application, and in addition to that we are filing the application that is known as the divisional application. So the divisional application must not contain matter that has not been mentioned in the original application. It means that whatever we have included in the initial, the basic application, that will be in this application too. And the divisional application can be filed at any time after the filing date of the original application, but before the original application satisfy all the grant conditions mentioned in the Act. It means that before we getting the patent, we must file this divisional application if we want to gain that. Okay, so that is about the types of patent applications. Now, so far we have discussed about patent. That was our first intellectual property. Now let's move on to the second intellectual property, that is the trademark. A trademark is a word, phrase, symbol or design, or combination of words, phrases, symbols or designs used in the course of trade, which identifies and distinguishes the source of good or service of one enterprise from the others. Okay, or it is a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from the other. So what distinguishes? A trademark, it may be the presentation of the brand name or the catching words that they use. So what makes it different, or what makes it distinguished from the other products, is known as the trademark. Okay, it may include the shape of goods, their packaging, the combination of colors, and covers both goods and the services. So that is what we know as the uh, trademark. So being an inclusive definition, from this we can't exactly mean what is a trademark. Mark may be a device, a brand, heading, label, ticket, names, the packaging, the size. So it will thus include any mark within the definition of trade. So that the mark is capable of being represented graphically and is capable of distinguishing the goods and services of one person from the others. So what distinguishes? Whether the name or the catching words or the package or the color combination, so that is known as the trademark. Okay, that is simply about the trademark. Now let's look about the registration procedures of a trademark. The registration procedure in India is based on the first to file system. First to file system means whomever initially submit the application for the particular trademark will get access to that of the trademark. It is therefore important that the rights holders applies for the registration for marks as soon as possible. If both of the companies have the same type of trademark, then whomever file the application first will gain access to that of particular trademark. And the registration of a trademark in India is typically takes about 2 to 3 years, and the subject to the trademark is not being opposed by the third party. So if it is not opposed by a third party within 2 to 3 years, we get a registration certificate. And the office of the Controller General of Patents, Design and Trademark is the appropriate office for filing of a trademark application in India. Okay, so the Office of the Controller General of Patents, Designs and Trademarks is the appropriate office for filing a trademark application in India. And the office has branches in Mumbai, Delhi, Chennai, Ahmedabad and Kolkata. A trademark application may be filed in any of these offices based on the territorial jurisdiction. So it is based on the applicant's territory. We can apply it whether on Mumbai or Delhi or Chennai or Ahmedabad or Kolkata. So after the application has been filed, the trademark office reviews it to ensure that it is complete. Okay, after filing any kind of application, the office will ensure, they will screen the application and ensure that it is complete in all respect, and thereafter allows an application number to the particular application. So if it is uh, filled accurately, they will issue an application number, and if the trademark is once get registered, the application number will become the registration number. Okay, and then during the process of examination, the trademarks office determines if the trademark is barred or for registration, either under any absolute grounds for refusal under the Trade Act 1999. Accordingly, they issue an examination report and the applicant must respond to the objections that has been raised in the examination report within a period of 1 month from the issuance of the examination report. So it means that once the office has found some objections regarding awarding this particular trademark, then they will issue a report and the applicant must respond within a month and must give the necessary explanations. Okay, and after that, so thereafter and based on the response to the examination report that has been filed by the applicant, the registrar of trademarks determines if the application should be refused or accepted for advertisement. But accepted subject to certain limitations, or put off for a show cause hearing during which the application might be accepted, rejected or accepted subject to certain limitations. Okay, so once we have given the sufficient explanations, it is up to the registrar of the particular department to take necessary precautions or necessary steps. It may be if he is satisfied with the explanation that we give, it will accept our application, or it may be rejected. If it is not, the explanation that we have given is not sufficient, then there will be a hearing during which there is another option for the applicant to give further explanations regarding his work. And if the application has been rejected, the applicant can approach the Intellectual Property Appellant Board to appeal the order of the registrar to the trademark. So, even after the hearing, if the registrar rejected our application, we have another way to approach this, and that we can appeal against the order of the registrar in the Intellectual Property Appellant Board. So within 3 months of the publication of the trademark in the trademark journal, and if it is not opposed by a third party, then we will get registered. The trademark registration authority will give us a registration certificate, and our application number will be the registration number. So in the specified time, the third party with the sole proof can oppose, and there will be a hearing of the applicant, and if we provide the necessary documents and explanations, if it is in favor, then we get registered, or it will be cancelled. So everything should be in a specified time. That is very much important. Okay. So then there are some rules regarding the opposition against this registration. It is detailedly explained in the section 21 of the particular act, but it is not relevant to us. So just remember that it is specified in the section 21. So, the registration of a trademark confers on the registered proprietor of the trademark the exclusive right to use the trademark in relation to the goods and services in respect of which the trademark is registered. So, once we got registered, it is absolutely our own, so we can use it in commercialization of our goods and services. So that is all about the trademark. There is not much to detailedly explain about trademark like that of patent. Simply what is trademark and the procedures for the registration of the particular trademark is enough. And if anyone wanted detailedly understand about the oppositions, again is, or what are the oppositions, or whom can apply, actually any third party with sole proof can apply against this particular trademark. Next is about our final intellectual property, that is the copyright. Okay, so what is a copyright? Copyright is a right given by the law to creator of literary, dramatic, musical and artistic works and producers of cinematograph films and sound recordings. Okay, it is actually a bundle of rights. Okay, it includes so much rights: the right of reproduction, communication to the public, adaptation and translation of the work. It means the sole right to produce or reproduce the work or any substantial part thereof in any material is to the creator only. Okay. So copyright means a bundle of rights, means it is mainly dealing with the literary world, okay, the literature world. So it includes the rights of that of artists, the artistic field means that of the writers, that of the song producers, cinematographers, everybody. Okay, and actually we must understand that copyright protects the expressions, not the ideas. So there is no copyright in an idea. So if about a particular type of art form, or it is not about a particular type of art form or a particular idea or a particular concept. Actually, copyright protects the expression of idea. It means that we can't just copy paste, someone else's work and claim to be ours. So that is what copyright protects. And the law of copyright do not protect ideas, but they deal with the particular expression of ideas. Okay, they are protecting the way that we are expressing an idea, but not protecting the idea. It is always possible to arrive at the same result from independent sources. Okay, it is possible. And the main objective is the protection to the owner of the copyright from the dishonest manufacturers who try to confuse the public and make them believe that the infringed product are the products of the owner. So it actually protects the owner's right over his own creation. Okay, so in artistic works there are so in each and every field, okay, the copyright actually protects a number of sections. So in particular here I mentioned particularly about the artistic work, what all things are considered as illegal. For example, reproducing the work in any material, okay, which includes storing it in any medium of electronic means and communicating the work to the public, issuing the copies of the work to the public which are not already in existence, including work in any cinematograph films, making adaptations of the work without the permission of the creator. So all these actions are considered to be illegal. So we can't reproduce someone else's work without their permission. So all these are protected under the Copyright Act, and it not only the artistic work, in case of computer programs also it is protected under the copyright. It means to sell or to give on commercial rental or offer for sale or for commercial rental any copy of the computer program is considered to be illegal. So artistic work, and it gives protection to artistic works, the computer programs, and the different types of artistic form. It may be a paintings or poems or songs or films. So there are so many subgroups coming under this copyrights. We don't need to go for that extent. So the copyright gives sole right to the creator on his work. So any claim on that work or use or copy that work without the permission or knowledge of the creator is illegal. Okay, that is what we need to understand. Without one's permission, we can't take their work. So far, we have seen some of the intellectual properties specified in our syllabus. They are the patent, the trademark, and the copyright. But there are many other types of intellectual properties, and new ones are forming due to the development in technology as well as in the literature field. So let's look into some of the other intellectual properties briefly. Okay, the first one is trade secret. Okay, I'm not going into much details. The trade secret, it may be a confidential business information that provides an enterprise a competitive edge. Usually, these are manufacturing or industrial secrets and commercial secrets. These include sales method, distribution method, consumer profiles and the advertising strategies, list of suppliers and clients, and the manufacturing process, etc. So contrary to patent, the trade secrets are protected without a registration because it's a secret. No one exactly, someone outside that the firm, okay, someone who is not the creator, not about the trade secret. Okay, a trade secret can be protected for an unlimited period of time, but a substantial element of secrecy must exist so that, except by the use of an improper mean, there will be difficulty in acquiring the information. Okay. So, considering the vast availability of a traditional knowledge in the country, the protection under this will be very crucial in reaping benefit from such type of knowledge. Okay, so that is a trade secret. For example, a recipe of a well-known food product in the market. So, some ingredients are not disclosed by the manufacturer. Okay, that is known as the trade secret. It is not just a recipe, there are so many other types, like it may be the advertising strategies. Also, what makes them the best? So they are not disclosing it, they are known as the trade secrets. It is not protected with any registration. It is their sole right to protect or to hide it from their consumers. Okay, so another type is geographical indications. Okay, it is defined as the indication which identify goods as originating in the territory of a member or a region or a locality in that territory where a given quality, reputation, or other characteristics of good is essentially attributable to its geographical origin. Usually, wines and spirit markers are particularly concerned about the use of a place name to identify the products, and the TRIPS agreement contains special provisions for these products also. And some people uses this geographical indications as a trademark also. So we must clearly understand that the trademark and the geographical indications are two intellectual property. We must be able to distinguish between them. Okay, so trademark, if a trademark is just a brand name or something, or just to distinguish it from other products. So if a product has a trade name with a geographic indication, means a particular name of a place. It doesn't mean that particular product is originated from that place if it is a trademark, but if it's a geographical indication, it means that it is originated from that particular locality. So that is about the geographical indications. Next is about the plant breeder's right. Plant breeders' rights are also a form of intellectual property which is specifically designed to protect new plant varieties. The rights as defined by UPOV is an exclusive right over the commercial production and marketing of the reproductive or vegetative propagating material of the protected variety. So it is actually specified for the plant breeders' right. So that is all about the plant breeders' right. So today we have discussed about intellectual property. We have came across what intellectual property is, how it is evolved through time, and then the intellectual property protection in India. Then we have discussed in detail about the three types of intellectual property: the patent, the trademark, and copyright. And we have also briefly mentioned about some other types of intellectual property like the trade secret, geographic indications, and the plant breeders' right. I hope it is clear to all. Thank you. And in the next video, we will discuss about Indian Patent Act, its new amendments, and how new GMOs are protected. Thank you.